Ever wondered why police officers touch your taillight during traffic stops and what you should do the second it happens? That simple touch can turn into evidence against you. And if you don't know the legal countermove, you could walk into court already at a disadvantage. Most drivers have no idea this tactic exists or why it matters until it's too late. Hit that subscribe button right now, because what I'm about to break down could protect you from a conviction, even if you've done nothing wrong. This taillight tactic is used in thousands of traffic stops every single day. And I'm going to give you the exact response that protects you. Here's what you're about to learn. The real reason officers touch your taillight and how it can be used in court. The precise words to say the moment you notice it happening. The Supreme Court case that supports your legal move. And how body cam footage shows that drivers who understand this walk away, while those who don't often end up convicted. I've reviewed over 200 traffic stop videos, and the pattern is clear. Drivers who understand this taillight tactic consistently have better outcomes than those who don't. Let's talk about why this moment matters so much. When an officer touches your taillight, two things are happening at once. First, they may be leaving fingerprints on the vehicle in case a driver flees. That's the official explanation. But there's another important reason. They may also be checking whether the taillight is cracked, damaged, or loose. If it's already broken, or becomes damaged, that can create reasonable suspicion for a vehicle defect. That, in turn, can justify extending the stop, calling for backup, or investigating further. This is legal for them to do, but your countermove is also completely legal, and almost no one knows about it. Here's what most drivers do wrong. They stay seated, hands on the wheel, waiting. They hear the tap on the taillight and ignore it. The officer approaches, asks for license and registration, and the driver hands everything over without thinking twice. That's the mistake. You've allowed physical contact with your vehicle without documenting the condition of that taillight beforehand. If the taillight is later claimed to be cracked or broken, the officer's report becomes the primary evidence. You have no record of its condition before that moment. Now picture the courtroom. The prosecutor says the taillight was already broken. You say it wasn't. The judge reviews the officer's report. Without evidence to the contrary, the report carries weight. You lose. You pay fines. Insurance rates increase. All because you didn't document what happened. So here's what to do instead. The moment you notice the officer touch your taillight, you calmly take out your phone, open your voice recorder or video camera, and clearly state, "Officer just made contact with my taillight at 9:42 p.m. My taillight was fully functional before this stop." Say it clearly, exactly like that. If you have a passenger, ask them to film the taillight from inside the vehicle. This creates a time-stamped record in real time. You're not being disrespectful, you're not refusing anything, you're simply documenting the interaction. Defense attorneys recommend documentation. Former officers have acknowledged that drivers who document stops tend to receive more careful treatment. If the matter ever reaches court, you now have a record that you stated the condition of the taillight at the exact time of the stop. That makes it far more difficult to argue the damage existed beforehand. Here's the legal foundation. In Pennsylvania v. Mimms, the Supreme Court ruled that officers can order a driver out of the vehicle during a traffic stop. But nothing in that ruling prevents you from documenting what's happening to your property. Courts have repeatedly affirmed that you have a First Amendment right to record police during public interactions, including traffic stops, as long as you are not interfering. You're allowed to create evidence. That right matters. Have you ever noticed an officer touch your taillight and wondered why? Drop a comment below if this has happened to you, because most people never even realize it occurred. Now let's move to the second tactic, and this one can be even more impactful. After the officer touches your taillight and walks up to your window, here's what usually happens next. They start asking questions. Where are you coming from? Where are you headed? Do you know why I pulled you over? These sound like casual conversation. They're not. Every answer you give can be used to extend the stop and justify further investigation. Many drivers believe being polite means answering everything. That's incorrect. Being polite does not mean giving up your Fifth Amendment rights. Here's exactly what you say. When the officer asks where you're coming from, you calmly respond, "Officer, I'm not answering questions. Am I being detained or am I free to leave?" Those exact words. Calm, clear, no attitude. Then you stop talking. This is critical. Silence is powerful. Officers are trained to ask follow-up questions. Most drivers feel uncomfortable with silence and rush to fill it. Don't. Ask your question, then wait. The officer will likely respond that you're being detained for a traffic violation. That's lawful. Now you say, "I understand. I'm not answering questions without my attorney present." Again, calm and clear. This approach comes directly from established Supreme Court precedent. Traffic stops are supposed to last only as long as necessary to address the reason for the stop, typically writing a ticket or issuing a warning. But when you start answering investigative questions, your responses can create reasonable suspicion that allows the stop to expand. Now let's compare the wrong way and the right way. Wrong way. "Officer, where are you headed?" Driver, Just driving home from a friend's house? Officer: Which friend? What were you doing? How long were you there? Have you had anything to drink? Do you have anything illegal in the car? Now the stop is expanding. Right way. Officer: Where are you headed? Driver: I'm not answering questions. Am I being detained or am I free to leave? The officer recognizes you understand your rights. The focus returns to the traffic violation. The ticket gets written. The stop concludes. The legal structure behind this comes from Miranda v. Arizona and Berkmer v. McCarty. Miranda established your right to remain silent. Berkmer clarified that those protections apply during routine traffic stops, even though you are not formally under arrest. When you combine those rulings, the result is simple. You are required to provide your driver's license, registration, and proof of insurance. You're not required to answer investigative questions. Everything beyond identification documents is optional. If this is already changing how you think about traffic stops, drop a like. Because what comes next is the part that prevents vehicle searches. Now we move to the third tactic. And this is the moment that decides everything. At some point, the officer may ask, "Do you mind if I search your vehicle? Can I take a quick look inside?" This is the turning point. If the officer already had legal grounds to search your vehicle, they wouldn't need your permission. The fact that they're asking means they're seeking consent. Most drivers say yes because they think refusing makes them look guilty. That's a mistake. The moment you consent, you waive your Fourth Amendment protection against warrantless searches. Here's what you say instead: I do not consent to any searches. Word for word. Clear, direct, do not explain, do not justify, do not add, I don't have anything to hide. Just state the line and stop talking. This is completely lawful. Consent searches are one of the most common ways evidence is obtained. If you agree, anything discovered is generally admissible in court. If you refuse, officers must rely on independent reasonable suspicion or probable cause to proceed. And if a search happens without proper legal grounds after you clearly refused consent, your attorney can file a motion to suppress the evidence. If granted, that evidence is excluded. Without evidence, cases collapse. Let's look at both outcomes. Wrong way. Officer: Can I search your car? Driver: I guess that's fine. Search happens. Something minor is found. Charges follow. In court, the judge notes that consent was given. The evidence stands. Right way. Officer: Can I search your car? Driver: I do not consent to any searches. If a search occurs anyway, the prosecution must justify it under the law. If they cannot, the evidence can be suppressed. The Supreme Court addressed consent searches in United States v. Drayton. Confirming officers may ask for consent, but individuals have the right to refuse. In Florida v. Bostick, the court reinforced that refusing consent cannot, by itself, create reasonable suspicion. You are legally protected when you say no. Now let's move into the fourth tactic, because this is where many drivers lose their resolve. Here's the fourth tactic. And this is where pressure increases. After you say, I do not consent to any searches, some officers push back. They might say, if you have nothing to hide, why won't you let me search? This is psychological pressure. It's designed to make you feel defensive or guilty. Most drivers give in at this moment. Don't. Here's what you say. Officer, I'm exercising my constitutional rights. I do not consent. That's it. No arguing, no debating, no explaining. Just restate your position calmly. Another version of the pushback is this. I'm going to call a K-9 unit. Let them. Calling for a K-9 unit is lawful. But under Rodriguez v. United States, officers cannot extend a traffic stop beyond the time needed to handle the original violation just to wait for a dog, unless they already have reasonable suspicion of criminal activity. That means this. If they already have reasonable suspicion, the K-9 is coming regardless of your consent. If they do not have reasonable suspicion, they cannot prolong the stop solely to wait for the dog. Once the citation or warning process is complete, the stop must end. Your refusal to consent does not create reasonable suspicion. So when pressure increases, you remain calm and repeat, I do not consent to any searches. Now, let's put everything together step by step so you can see exactly how this plays out in a real-world scenario. You're driving home at night. You see flashing lights behind you. You safely pull over. You turn off the engine. You turn on your interior light. You place your hands visibly on the steering wheel. The officer approaches and taps your taillight on the way up. Immediately, you take out your phone and state clearly, Officer just made contact with my taillight at 10:15 p.m. My taillight was fully functional before this stop. Now the interaction is documented. The officer reaches your window and asks for your license and registration. You hand them over politely. Then comes the question, do you know why I pulled you over? You respond calmly, I'm not answering questions. Am I being detained or am I free to leave? The officer replies, you're detained for speeding. You respond, I understand. I'm not answering questions without my attorney present. The officer asks again, where are you coming from? You remain silent. They repeat the question. You calmly repeat, "I'm not answering questions." The officer returns to their patrol vehicle to run your information. After a few minutes, they come back with a warning. Then comes the key moment. "Do you mind if I take a quick look in your vehicle?" You respond clearly, "I do not consent to any searches." The officer says, "Why not? Do you have something to hide?" You reply, "Officer, I'm exercising my constitutional rights. I do not consent." There's a pause. Then the officer hands you the warning and says, "You're free to go." You leave. No search, no extended detention, no collected evidence. Now compare that with what most drivers do. They don't document the tail light contact. They answer every question. They consent to the search out of nervousness. The officer finds something minor, an empty container, a small item that creates suspicion, something misunderstood. Now there are charges, all because the 4 counter moves weren't used. The legal structure tying this together includes several major Supreme Court rulings. Terry v. Ohio established that officers need reasonable suspicion to detain and probable cause to search. Pennsylvania versus Mimms confirmed officers may order drivers out of vehicles, but did not remove other constitutional protections. Schneckloth v. Bustamante ruled that consent searches are valid only when consent is given freely and voluntarily. If consent is pressured or unclear, it becomes legally questionable, but you must clearly invoke your rights for those protections to apply. These cases protect you, but only if you use them. We're almost done. Let's recap everything clearly and directly. Here's a full recap of the 4 tactics you just learned, the ones that protect you during traffic stops. Tactic 1, document the tail light touch immediately. Pull out your phone and say out loud what just happened and the time it occurred. This creates real-time evidence that the tail light was functional before any contact. Tactic 2, refuse to answer investigative questions. Calmly say, "I'm not answering questions. Am I being detained or am I free to leave?" Then stop talking. Silence is your strongest tool. Only provide your license, registration, and proof of insurance. Nothing more. Tactic 3, never consent to searches. When asked, clearly state, "I do not consent to any searches." If the officer pushes back, calmly repeat, "Officer, I'm exercising my constitutional rights. I do not consent." Tactic 4, stay calm and silent after invoking your rights. Anything you say after stating your position can still be used against you. Do not explain, justify, or argue. Repeat your line if needed, but remain composed. Here's the reality. Officers are trained to investigate. They're trained to get consent. They know how to ask questions that encourage you to give up your rights without realizing it. This isn't illegal. It's how the system works. But now you know the legal counter moves. Drivers who use these tactics consistently walk away free. Drivers who don't often end up in court over charges that should never have existed. Hit subscribe to make sure you catch the next video where I reveal exactly what to say when an officer claims they smell marijuana in your car. That tactic is responsible for more arrests than almost anything else. And the counter move is something 99% of drivers have never heard of. Smash that like button if this just saved you from a future arrest. Drop a comment telling me which tactic shocked you the most, or if you've ever had a cop touch your taillight. Stay safe out there. And remember, knowledge is your strongest protection.